All right, well, welcome. It's good to see you all here. The first thing I wanted to say was this is truly, I'm marveling at the fact that this is a heroic panel, for sure. If I could tell you the stories behind this panel, you would be amazed. You would think, oh my goodness, I was so lucky to have been there, and you would not forget this day. But I have to say, they have traveled far and through difficult circumstances. And Professor Drexler is up quite late in Germany right now and is joining us by Skype. But we're very appreciative for having everyone here. So I just wanted to say a couple of things to start out with. And the first thing is, surely there can be no more important thing than intellectual property. So I want to make that clear, that everyone else who has traveled here, you're really not that important. It's truly intellectual property law that's important. As one of my friends said one time, one U.S. Court of Appeals for the Federal Circuit decision came out, and so this is a court that has nationwide exclusive jurisdiction over patent appeals. This one case comes out, and it caused a $100 billion shift in the stock market. One case, $100 billion shift in the stock market. What is more important than money? I mean, I don't know what it is, right? Money's quite important. Clothes, okay. So fashion, yes, important. So money, right? And I would even go so far as to say money is power, all right? Now, all that said, I need to go and talk about Professor Sprankling. So Professor Sprankling, when I read his book, and I'm going to have to read it a few more times to get my head around it completely, but it exemplifies just who John is in a lot of ways, which is careful and deliberate. When you read that book, there is such a high level of detail as he works through these treaties. And he is very careful about what he says. He is very careful. And I think he frames this idea, this emergence of an international law of property very well. So he is setting the stage for future debate, which I found fascinating. Now, John, again, is very careful, and when you read his book, he takes into account distributive justice issues, okay? And he notes that they exist. There's a sensitivity there to that. Now, here at McGeorge, and I don't think Professor Carter is here, but a couple of years ago, we did a symposium on human rights in the law. And part of that was a panel on human rights and intellectual property. And some of the discussion concerned the right to access to things like educational materials and the right to access to medicines as well. So when you look at these two symposiums together, I think you're kind of seeing something kind of evolve, which is very interesting. Okay, it's very interesting. Now, I said this at the last symposium when I moderated the IP panel, and that was that, when I think about these issues, at least for me, I think about the sociologist Richard Florida, who wrote the book The Rise of the Creative Class, which is very popular. And I saw him do a lecture on this particular book, and he talked about how he views problems. And he says he views problems sometimes, depending on what the problem is, from the perspective of a citizen of the city he's in, the state he's in, his country, but then also as a citizen of the world. And I think that's a really important point whenever we think about, this convergence of law, which I think my colleague is right descriptively, that we have an international right of property coming forth. So I'm excited about that. I think of property as power. I don't know, process is power, money is power, there's a lot of power. Okay, so we have three great panelists, and I'm really excited about them. Our first panelist is Dr. Josef Drexl, who's the managing director of the Max Planck Institute for Innovation and Competition. He's also an honorary professor at the University of Munich. He's an expert in IP and competition law. He served as a professor in Würzburg and in Munich, and as a visitor at the University of Oxford, Lewis University in Rome, and at the New York University. His talk is titled Between Propertization and Regulation, How a Fundamental Rights Approach Could Solve the Tension. Our second panelist is Margo Bagley, who is a Hardy Cross Dillard Professor of Law at the University of Virginia Law School. She practiced law at the Finnegan Henderson Law Firm, which is the largest intellectual property firm in the world, and has taught at Washington and Lee, Emory in Germany, China, Israel, and Singapore. She served on the National Academy of Science Committee and on the Scientific Committee of the 2013 European Policy on IP Conference in Paris, France. She is also an expert for Mozambique for the World Trade Organization. Her talk is going to focus on issues with respect to the emergence of our international property right. Now, our final panelist is Ms. Irene Calboli. And Dr. Calboli is a professor of law and director of the IP and Technology program at Marquette Law School. She's also a professor at the National University of Singapore. She has authored many works on IP law and has served as a visiting researcher at numerous institutions, including the King's College in London, UC Berkeley, the Max Planck Institute for IP in Munich, and the University of Madrid. So her talk is titled, Are Trademarks Property the International IP Debate on Trademark Transactions? So we're going to go ahead and start with Professor Drexl, and I believe we'll have questions after all the panelists are complete. So thank you very much. Professor Drexl, are you ready?
Yes.
Okay, I'm manning the PowerPoint, so if there are any problems with the PowerPoint, it's all my fault. All right. Oh, Joseph, we can't hear you. My apologies. You'd think the IP panel could get this right. But apparently we can't, so I apologize. Yeah, the space panel. Is it working now?
It's kind of, I don't know if you're with that.
Okay.
I can get you a speakerphone to call.
A speakerphone and call you? So Joseph, we're going to get a speakerphone. The Skype is not working very well. So it's okay, we might have Margo go now and then have you go after Margo. Is that okay? Okay, thank you very much. Oh, are you, is it okay if you go down? Okay, so I'm going to move this. Do you want to sit in my seat or would you like to sit? Stand. Okay. Let's see.
Thank you so much, Mike and Rachel, for inviting me. I'm delighted to be here, and Professor Sprinkling for writing a wonderful book. I think you're absolutely right that an international law of property is where we are, where we're heading, and there's some very important implications for that. I'm delighted to be here with you, not heroic, just, and thank you so much for moving the panel, and Josef and Irene, because my plane was hit by a snowplow yesterday, and so it didn't take off. Who would have thought it? So I'm really glad to be here after all. But while I agree that an international law of property is where we are, where we're headed, a lot of the elements are in place, I'm not particularly sure it's a good idea, at least for intellectual property. And I want to share some examples with you of why that might be. I'd like to talk, I was asked to talk about international law of IP in relation to harmonization and morality, which I'm going to do, and also global minimum standards, which is one of the points that Professor Sprinkling discusses in his book. So national interest versus harmonization, national interest versus global minimum standards, and harmonization and morality. And I have too many slides, but I'm going to do the best I can to turn this all in. All right, so there is no doubt that intellectual property, and I'm going to be focusing mostly on patents. Patents is what I do. So there's no doubt that differences in intellectual property laws and differences in patent laws can affect or negatively affect businesses and consumers in other countries. And as one example of that, well, actually before that, let me say a little bit about what I mean by harmonization. And I'm not completely sure it's exactly the same definition that Professor Sprankling was using, because people, when they talk about harmonization, sometimes they're talking about complete or sometimes incomplete. But taken into its extreme, at least in the patent context, we'd be talking about a global patent system where you could go to one patent office and get a patent that would be valid in all jurisdictions, and there would be one court system applying the same laws to that patent. Same standards for patentability, same standards for infringement. And there are many right now who would love to see that. It would be very efficient for many multinational corporations, but it could be problematic as well. And I have this quote from the book: "Intellectual property is the leading example of how the international system harmonizes property rights, the concept that a uniform global legal regime should govern scientific, literary, and artistic creations from the standpoint of human rights, which logically extend to intellectual property rights as well." So this is a concept that is definitely out there. But the fact that we have these different laws, as I said, can have negative implications. I have an example here. This is a report by the United States International Trade Commission looking at China's infringement and indigenous innovation policies and their negative effect on the U.S. economy, saying that China's IP rights infringement, and China has long been considered a place of IP piracy, cost the U.S. economy $48 billion in 2009, and talking about the different sectors it came from. If China complied with their current international obligations, 2.1 million jobs could be created in the U.S. The most direct jobs would come in high-tech, innovative industries. Well, that's, great, but one can imagine that China is not particularly interested in creating jobs in the United States. China's probably more interested in creating jobs in China. And so when it made sense for China to start taking IP rights seriously, the Chinese government got behind patents with a vengeance. So I have this from the China National Patent Development Strategy, 2011 through 2020. And the important point is that here China has a goal of ranking in the top 2 countries in patents granted to domestic applicants. They're number 1. They've already reached that. And would file 2 million patent applications worldwide. And just for context, it's only been a year or so that we've had 2 million applications, period, filed by everybody everywhere. So for China alone to file 2 million is just a little scary. And China's been amazing. When they got serious about patents, this little red line, China's only had a patent system since '84. The Patent Office receives more applications than any other office in the world, outstripping the United States and Japan, South Korea, and the European Patent Office. So not so great necessarily for the United States, great for China. Interestingly enough, the Agreement on Trade-Related Aspects of Intellectual Property, which Professor Sprankling also talks about in the context of global minimum standards, is a very important treaty, largely because of the binding dispute settlement procedure that it has. Previous treaties, like the Paris Convention, Berne Convention, not a lot of teeth, because there wasn't a really good way to make countries comply if they were out of compliance with their obligations. Here, a country can bring an action against another country that's not complying, and there can be very serious repercussions. But the United States, which just complained about China not protecting IP rights, is actually the only country that, this is a list, and you can't see the numbers, but just so that you know, of complaints that have been filed under the TRIPS agreement. The United States is the only country that, after there has been a ruling against it, has not complied. And so in the 2 cases, there's a copyright case, a trademark case, 10 years and counting, 9 years and counting, where the United States chose not to protect rights in the way that it arguably was supposed to, according to the TRIPS agreement. So these are examples of national interests, and these national interests trumping sometimes the international obligations that countries have actually signed up for. Another example of national interest is patent validation. So one of the harmonization efforts that we see are patent offices trying to engage in work sharing, trying to minimize the debilitating redundancy, as one person put it, that's built into the system, that you have the same offices examining the same applications. It's like, well, what if we could have one office that does that, and let's give full faith and credit to the other offices. So the 5 big offices, the IP5, they've got various efforts going on to try to minimize minimize duplication and enhance work sharing. And I thought it was really interesting that the European Patent Office in particular, which grants patents for all of the EU countries as well as some other countries, it's not an EU organization, it's an international organization, but all EU countries are members, has this validating European patent program where they encourage countries that are not party to the European Patent Convention to allow inventors to validate European patents in their countries. What do I mean by that? It means that a patent application would be examined by the EPO. They decide a patent should be granted. Then you could take that as an inventor, as a patentee, to another country and say, here, give me a patent in your country. Okay? Sounds innocuous enough, definitely more efficient, but is that really a good idea? Not so sure, and I won't take the time to talk about that. I'm looking at who's filing applications in the European Patent Office. Well, lots by the United States, Germany, Japan, lots of large developed economies, not surprisingly. So what does that mean? That could be a problem for developing countries, okay? If they are getting lots of these foreign patents validated in their countries, then that's money that's flowing out to the wealthier countries. It might actually not be in their best interest, and there's a lot of fanfare. The EPO signed their first agreement that went into effect on March the 1st, just earlier this week, with Morocco for this program. And I've got a number of examples. I don't have a lot of time, so I won't go into all of the detail, but dangers of relying on outside examination. A big one is, even though it's touted as this can be really helpful, you don't have to have as many examiners in your office, you can save money, small country. You don't look at what happens to the patent after it's granted in the EPO or somewhere else. And as it happens, 66% of challenged EPO patents are revoked or at a minimum narrowed. This is not just the EPO. 50% of patents nullified in Germany that are challenged. In the United States, claims invalidated in 86% of cases where validity is challenged. And any of you who've been watching what the Supreme Court's been doing in Association of Molecular Pathologists versus Myriad Genetics, really effectively invalidating thousands of patents. So developing countries engaging in this validation, not looking to see whether those patents remain valid, that's potentially another problem. Oh, and also the JPO as well, where countries really should take into account their national interests in making sure that they are applying their patent criteria to applications that are filed in their office. Harmonization and morality. So this is another challenge. If you think about a truly harmonized patent law, you would have the same standards of patentability, and you couldn't really make exclusions. I have here a list of some controversial, morally controversial biotech inventions, things like transgenic animals, genetically modified plants, genes, methods of cloning humans, cloned humans, human embryonic stem cells, mixed human-animal chimera. All of these inventions, and they actually can be inventions, have moral issues associated with them. And the issues can be one of two types. Some people are concerned that the research should not be conducted, and patents are going to create an incentive for people to engage in this research, and a government-granted imprimatur that we might not want. And then we have some inventions where the concern is that actually we want to encourage this research, but we want it to be free to everyone. You can think of that in terms of the breast cancer genes, and that we shouldn't put certain kinds of information under a patent owner's control. Well, right now, in the United States, we don't have really morality limitations, but many other countries do. I have language here from the European Patent Convention, which has both a general morality provision, which allows for applications to be rejected on the basis of moral concerns. And then from the EU Biotech Directive has a variety of explicit exclusions, like human commercial uses of human embryos, methods of cloning humans, things of that nature. And these are, oh, I love this picture. These are things that people can have different views on, whether we want to encourage this, whether we want to patent this. So this is actually a sculpture. It's not an invention, but people have filed patent applications on human-animal chimera, mixed human-animal species. And again, if we have a truly harmonized patent law, yeah, great, people might not be able, the countries might not be able to make those exclusions. TRIPS does allow this right now. TRIPS does allow members to exclude from patentability inventions whose commercializations would prejudice or to public morality, things of that nature. So does that mean that global minimum standards, such as we have in TRIPS, is that the way to go instead of harmonization? Maybe, maybe not. So I do have some examples of concerns with national interests versus minimum standards. And it was interesting to hear that you recently had a symposium on access to medicines, because I'll be dealing with a couple of those kinds of examples. But here's another quote from Professor Sprankling's book. The adoption of global minimum standards is a useful tool for harmonizing municipal laws while also affording states a degree of autonomy. And we could see that with the morality question. The standards that TRIPS mandates for patents are also minimum requirements. Minimum. They're a floor, not a ceiling. Countries can impose higher levels of protection. That all sounds good, but is there a problem with even these minimum standards of protection? Sometimes yes. So Thailand, and one of the things that TRIPS did, it required countries to grant patent protection in all areas of technology, except for those things that you could exclude. And that was largely to get countries that had not been granting patents on pharmaceuticals to start granting patents on pharmaceuticals. And TRIPS has a compulsory licensing provision, but it limits the circumstances under which countries can grant compulsory licenses. So Thailand is facing a serious problem in terms of HIV/AIDS infections, as well as large numbers of folks with chronic diseases, decided to issue compulsory licenses. A compulsory license allows a third party to practice a patented invention without the permission of the patent owner, but does allow for compensation to the patent owner. And Thailand issued compulsory licenses on 2 HIV/AIDS drugs and a heart disease drug, and got tremendous backlash. Abbott said they weren't introducing any new drugs in Thailand. The USTR put Thailand on a Section 301 watch list, which is a list that could result in sanctions. And there was this interesting op-ed by Ron Cass where he talked about Thailand's effective theft of pharmaceutical companies' intellectual property. Despite the efforts of health activists to portray the world communities accepting or endorsing this conduct, there's a growing appreciation that trampling patents to allow a middle-income nation to cut its spending on drugs seriously threatens the world's system of protections for innovation. All right, so we're seeing here the idea of this international law of patents, the idea that patent rights should be protected anywhere, that these are strong property rights that should be respected, that there's this concern about innovation if they are not. Is someone going to show me a little time thinking?
I think you're fine.
Okay, all right. Okay, wait for what? 5 minutes. Okay.
There's no judgment there.
Okay, all right, okay. But this, when I heard this, it bothered me, to put it mildly. To think of it as theft in the first instance, but again, if you have a strong property rights view, that makes sense. But this is a quote from back in 1976. It talked about patents in the third world being mostly foreign-owned, and that therefore the R&D allocations in developed countries where the inventions are being made and patented are not influenced by patent protection in the developing countries. So there's a divorce between patent protection and incentives for innovation. So to say that this seriously threatens the world system of protection for innovation is somewhat problematic. Oh, and I also have a note here. I showed my students just a couple of nights ago the movie Fire in the Blood. Has anyone seen Fire in the Blood? Excellent documentary about the battle to make affordable HIV/AIDS drugs accessible on the continent of Africa. And one of the statistics shared by Jamie Love in that movie was that the entire continent of Africa, profits for pharmaceutical companies, was less than 1%. Okay? For the entire continent. Okay? So they're not making any decisions about what research to do or what drugs to develop based on these poor countries. They're basing it on what diseases we're seeing in the United States, where 50% of pharmaceutical company profits come from. And this is another illustration of this. This is from WIPO, the World Intellectual Property Organization. They do great statistics. But it shows the majority of patent applications in developing countries are filed by foreigners, the dark green being non-resident applications, light green being domestic applications. In high-income countries like the United States, you've got a pretty good balance. Upper middle income, China throws this all off because China has so much domestic patenting. But lower middle income, low income countries, most of the patents are owned by foreigners, and that's problematic. And this was also interesting in thinking of the Thailand situation. In 2006, Thailand had an average per capita income of $819 per day. For the bottom 80%, the average was $522 per day. So for the Plavix, heart disease drug, the pre-compulsory licensing price was $2 per day, or nearly 40% of the average income of the bottom 80% of the population. So to say it's a middle-income country, still, when you look at what that income is for the people who would actually be in the public health system who would be accessing the drug, one can understand why Thailand might want to grant a compulsory license. All right, so I'm almost out of time. Yeah, so intellectual property, and I will just show this real quick. The view of Dean Cass is what Professor Ho calls patent as an uber right. And Josef, I don't know if I said the right, but uber right, stronger than other property rights, deserves a special status because they provide these words for innovation. But there are other scholars, and I think of Peter Drahos in particular, that says, well, no, patent's really a privilege that also comes with obligations, and it's a tool. And innovation is one of the goals that we have, but it's not the only goal that we have, and we need to keep it in perspective, we need to keep it in balance. And the idea that intellectual property is more obviously a creation of the state than other sorts of property, and actually perhaps enjoys less of a moral right than other property claims. And I think this is reflected in the United Nations Subcommission for the Protection and Promotion of Human Rights. They came out with a resolution, this was back in 2000, we were having so much going on with TRIPS and HIV/AIDS, that the implementation of the TRIPS agreement does not adequately reflect the fundamental nature and indivisibility of all human rights, including the right to health, food, self-determination. There are apparent conflicts between the IP rights regime embodied in the TRIPS agreement and international human rights law. And I think that's true, and I think that's what we see, and actually Professor Sprankly pointed to a number of those issues that we have with this emerging and developing international law of property, and in particular international law of intellectual property. My final example relates to India, a really interesting country that after independence decided to take a closer look at its patent system and whether it was working well, and concluded that it was not, especially in the area of pharmaceuticals, pointing out that most of the patents were foreign-owned, prices of drugs were very high in India, and yet the income of its citizens were very low. And India made a strategic decision to stop granting patents on pharmaceutical products. You could get a process patent, but not a product patent. And it was amazing what happened. And this would not necessarily work for every country, but before 1970, almost 90% of patents owned by foreigners. There were lots of pharmaceutical companies, some very, very small. Most drugs imported, very expensive drugs. But after 1970, and then looking at 2006, you have this vibrant generic drug industry that is not only providing low-cost drugs in India, but is exporting them around the world. It has definitely helped with employment. You have technological development, absorptive capacity for technology. Huge difference. This is a national interest example of India saying, you know, patents don't work for us on pharmaceutical products at this stage of our development. So I think that's a really important issue that is not always taken into consideration when we're looking at international IP or property rights. What is a country's state of development? What kinds of protection make sense at a particular time? And as Professor Sprankly notes, unless appropriate precautions are taken, the globalization of property law may threaten the poor in general, communal societies in particular. And when you think of how minimum standards in TRIPS has required India to now grant patents on pharmaceutical products, it's hard to see how we can take appropriate precautions to make sure that the next generation of drugs will be available at reasonable prices to those in the developing world. So to conclude, the internationalization of property, not necessarily a good thing in IP for all countries. There is, I think, a hierarchy of rights that we need to keep in mind, and that IP probably should have a lesser claim. And that territoriality in IP law has advantages, again, for particular countries over harmonization. Actually, not just developing, as we see the United States uses it to its advantage sometimes as well. So thank you very much.
All right. So what I'm going to do, in the interest of transparency, I'm going to try to get Professor Drexl. Let's see if the technology is going to work. So, oh, we have a speakerphone. Okay, so should we install that? Okay.
Does somebody have his phone number?
Lee probably has this phone number. Yeah, we need to look for Lee. Okay.
Sorry, dude.
Hello?
Hello. Yeah, the audio's still not working good. Can we call you over the phone? Joseph? Can we call you over the phone?
Were you able to get his phone number?
I did.
Oh, okay. Were you able to get a phone number?
I asked Lily to try to get that from me.
Can we ask him?
I'm working on it.
Okay.
Can we call you on the phone? I just not seeing it. Trying to see if you can see it. He's not seeing it. I don't know if he's not hearing me apparently. Can we call you over the phone? I can't do anything on this phone. I don't know. I hope so. Can we just take a 5-minute break so we can get this squared away?
Sure. We're going to go ahead and take a 5-minute break while we get the technical issues settled. So,
to affect innovation, patent has really a right to freedom if you take it away. But American didn't have any problem until 1999 not respecting the rights of copyright of foreigners unless they were simultaneously published. And they joined the Berne Convention only because they wanted their software protected. And back then they decided, okay, we have to join them. We want everybody else to protect our pharmaceutical and our software, so we give up. And at this point we joined the Berne Convention. But until 1989, we were saying we are a young country. We have to we cannot, unless there is a simultaneous publication and respect of formalities, we cannot really protect everybody else. The same with trademarks. In trademark law, we have one of the weakest systems in the whole globe in protecting marks. Perhaps because we like to copy the European designers, we like to copy. I often say natural rights, utilitarian, and down to the money, as Mike was pointing out, money is power, and if we don't produce that, it's not that valuable for us, so the law can actually be a little bit less powerful. So every country does what in many ways is more convenient for them, which might be a good solution. However, then it's important to remember that India has the right to issue a provision in which the standard for non-obviousness in patent law is higher, and they're not thieves. They are, simply put, doing what's best for their own jurisdiction. Most countries in the common law world, but the United States, a very strong statutory exception for copyright, for example. I teach in Singapore, and in Singapore I can post everything on the web in our internet for my students. They spend nothing compared to what American students have to spend for books. And we pay statutory licensing, and the university takes care of that, which is a negotiated price, very fair. Many books are subsidized heavily by the government, so the price is much less. And that is an adaptation, it's a flexibility under the international copyright system. Compulsory license doesn't work as good as it could. However, until 2000, we didn't have many, but after that, we start to see more and more. Indonesia issued one not too long ago. India's been issuing several. These are flexibilities, and in many instances, we also have a lot of flexibilities in the damages. In the United States, you or somebody downloads 3 songs, you can be liable for $1 million+ dollars. In the rest of the world, where sanity, in my opinion, prevails, the cap is $200,000. It's still a lot of money, but you are not going to see those skyrocketing deterrent, you stole, this approach, again, natural right, sense of guilt. There is a lot of these principles that goes behind some of these. We don't want to put any limit, the government should not interfere, a lot of these American philosophies, for example. In many countries in the world, patent infringers are not still infringing, but are not liable for damages unless they are put on notice. That's not the case in the United States. So there too, having flexibility in the enforcement and damages area is very, very important, because even if a right is awarded and an infringement is found, at the end, what's really important is how much money I owe. Sure, if I'm a business, I have an injunction, I still have to stop, but I have, at least I don't know, I don't have to pay millions in damages. Singapore, which is a jurisdiction known for the rule of law and very pragmatic, had to implement the provision on well-known trademarks, and so the dilution provision, because of the FTA with the United States. The well-known trademarks provision they added under the TRIPS agreement, but the US pushed even further with the FTA, so they wanted to make the US happy. They drafted the provision, but there are no damages attached to it. So the maximum you can get is the injunction. And the court have interpreted the threshold for fame so high that Louis Vuitton was very disappointed that their Quatre-Feuilles flowers that was not found to be famous enough to enjoy dilution. And so these are exceptions and limitation that's within pocket of national flexibilities, so national interpretation of the international flexibilities allow for more diversity. And these are, as Professor Drexl pointed out, are under threat, because who created the international IP system? Corporation and business and lobbyists. I'm not against business, but it's important, again, to understand that business is a way for society to redistribute. Market economy is probably the best functioning imperfect system. There are other systems that have not proven to be functioning because corruption, but there are also many good things about alternative systems. Yale Law School has been doing for 2 years in a row a series called IP Without IP. This year the theme is bring back in the state. So I'm sure people think that Yale is gone socialist, communist, they want more government. But it's exactly what it's about. It's creating spaces. Like Creative Commons is a space of licensing for very limited cost. So the property system, the market economy is the best imperfect system we have, but I see that as a public policy approach to business and redistribution. We don't really care for the 1%, at least we should not. We want everybody to have a decent living and everybody to be able to afford things and buy more things, etc., etc. In theory, there is a constitutional principle that is we all should strive for the pursuit of happiness. Perhaps that could actually be brought in scholarship, I think. Our property and our intellectual property can help individual, or actually are not helping individual, pursuing that happiness that the Constitution say we should all be able to pursue under the umbrella of freedom. And so I think it's important to remember that, because we need to build in a property and an intellectual property system, as I try to give some examples, those pockets of exceptions that are absolutely necessary. In the United States, we have good constitutional principles. I think that our courts have been using those to grant more rights, occasionally to take some rights away, but we see there is this idea that if we are against IP, is almost we are anti-American. We are known in favor of more work and more productivity, as if productivity always requires intellectual property. It does, but perhaps not to that level. We had a very flourishing industries, flourishing without too much protection. We think about fashion, we think about, for example, the chef, the cuisines. There are several areas, and in many ways, IP is stifling innovation in some areas, to actually pushing more and more litigation. And so again, it's just for those who can afford litigation. And so here I close. I think we need to have more attention to the international law of property. I think that would actually benefit both developed and developing countries. I believe that indigenous community and community might have to adapt. There is no one size that fits all, but recognition of right is key. It's very, very important, at least to avoid that we just go in and take their knowledge. However, it has to be very well thought through, and I think that David is really in the details in which we need to try to balance it. Perfection is impossible, but more attention to and thinking that not enough sometimes is better, and diversity is better than bad uniformity. Thank you very much.
Well, thank you. I guess we'll now open up to the audience for questions. So if you have some questions, please raise your hand. Okay.
I got a question.
This is great.
I was very interested in your presentations, which reminded me a bit of Matthew's presentation in the morning about the social function of property. And I don't know if you're familiar with that literature, but it seemed to me that much of what you were saying was the notion that perhaps intellectual property rights are, at least in some nations, too strong and need to be tempered with more concern for social values, which is very consistent, Matthew, which I think what you were saying earlier about the social function of property idea. So as you think about this issue, just sticking with the IP world for a moment, where would you like to temper existing IP rights in a way which is more consistent with the social function of IP or property in general? So just in the IP world itself, what would you like to see happen?
Are you...
Anyone.
Did you stop?
Well, I think you alluded to some things, and Josef did as well. The idea of building more flexibility. So if we take the U.S. System, there are not a lot of safety valves. That's one way to think about it. There's very strong rights, and something that I talk to my students about, we've seen recently a lot of patent subject matter eligibility cases. And it's like that's all that you can use when you don't have a vibrant experimental use exception, you don't have meaningful compulsory licenses, you don't have ways in which society can benefit from these inventions without the monopoly protection. Then you get people using the doctrines that are available in ways that perhaps they weren't intended, or expanding them. So yes, I believe that we should, and through experimentation as well, figuring out how to build more flexibility into the system without it being perceived as un-American and as, oh, you're destroying the system. No, the system actually is, I believe, quite resilient, and there could actually handle the balance better than what we have now. We don't really have much balance.
If I can interject on that, and then perhaps Joseph wants as well. I also think it's important to see a lot of this issue in context. In access to health, for example, I think the decision, there is a lot of politics behind some of the decisions. The Myriad case was decided to make those tests more affordable. What is interesting is that in Australia, the Federal Court of Australia decided basically a case on similar, if not identical, facts in favor of the patent holder. But Australia is a universal healthcare system in which prices of tests are less. Singapore is on the fence, but there as well, healthcare is subsidized. So in the United States, I tell my students all over the world, we are paying for everybody else subsidized healthcare. We should not forget that. And so everything has to be taken in context, I think. The parity decisions that we have for example, in country like the Netherlands, in which there is really small surface and very big melting pot, might be similar to what Singapore has, in which you really don't want to upset certain constituency because from a public order standpoint it's very difficult if that gets out of control. In the United States we believe more in freedom of speech, and so we are really going to push for fair use and transformation and so forth. So I think this issue there's no one size fits all also within these issues. They have to be looked holistically in the context that they are. Healthcare is one, access to education is another, and so forth.
Joseph, would you like to respond to the question?
Yes, of course. On the social dimension of intellectual property law, I fully agree. And there is a reason why the social dimension of intellectual property law is much more important than the social dimension of real property. Intellectual property doesn't only protect intangible goods, it also protects ubiquitous goods. What we protect is everywhere. It's knowledge. So intellectual property prevents people from getting access and using knowledge. And this has an impact on everybody, on the society at large. Whereas if you have a piece of land, the impact of that piece of land and the decisions taken by the owner are geographically very, very limited. So the impact, the social impact is much larger in the field of intellectual property. That's true for all intellectual property rights. Of course, it's most important in the field of patents when it comes to pharmaceuticals, where patents can actually prevent access to essential drugs and so on. That's very obvious. Maybe again, because some other speakers hinted at the parody case, it's certainly true that the U.S. court would take a different perspective on the case and maybe valuing freedoms of speech much higher. In Europe, however, what is very important is that we have a moral rights concept in copyright law, which is not enshrined in the American tradition. So without saying it, the court used the personal attitude of the copyright owner and his attitude to immigration as at least as much as the attitude of the one that used the work. And the owner of the copyright, the creator of the work, should not give his work or her work away for a person that wants to express a completely different view with which the copyright owner would not agree with. And then, since this attitude of the copyright owner was more highly valued in the under the Charter of Fundamental Rights, it was easy for the court to argue this way. However, the decision is very, very problematic because countries within the European Union value free speech very, very differently. For example, in Scandinavian countries, in Sweden, for example, the constitutional attitude to free speech is much closer to the US than to what maybe the Court of Justice held. So in this regard, the court goes very, very far by taking, I used the word used by Irene now, it's taking flexibility away from the member states and their legal systems. So in the European Union, where we are now, we have very, very limited flexibility, but that's actually what we have to accept under progressing harmonization in view of an internal market.
Well, I think we have maybe time for one more question. I know Mr. Perils has had his hand up for quite a while.
For Professor Bagley, could you comment on this phenomenon that is particularly prevalent in Silicon Valley of patent trolling? And specifically, it brings to the fore, I think, the question of fostering versus stifling innovation. And I think we broadly consider Apple to be one of the most inventive companies in the world, and don't quote me on this, but I think it was last fiscal year they spent 2 to 3 times as much acquiring technology developed by others than doing their own R&D. And of course, the Samsung versus Apple litigation seems to be a full employment act for lawyers, which is bad. But could you comment just a little bit on that issue?
It's a pain.
Yeah, there are a lot of issues associated with that issue, and I think Irene alluded to them as well. And I think there is a concern about these lawsuits stifling innovation. We have the litigation in the U.S. is very expensive. The patents themselves have a presumption of validity, so you have to use clear and convincing evidence to invalidate them, and it's easier, or it can be a economic decision for a company like, oh, I'll just pay, or I'll just go out of business. They simply can't afford it. And so we have people that are practicing the invention, or actually making and doing something, that are negatively impacted, and of course consumers end up being negatively impacted by these suits. And I do think it shows just a skewing of the system. I mean, there's always been gaming, and I just don't think Congress to this point has done enough. I was just reading a post, just yesterday, someone was looking at how patent litigation has been increasing just tremendously. I can't give you the exact statistics, but it's something like it doubled between 2004 and 2010, and then it doubled again between 2010 and 2013. The numbers, I mean, and then even with the venue changes that were made with the America Invents Act, when you correct for that, still increasing. So this is great for my students who I want to have jobs. That's always nice, but I don't think it is good for our society as a whole. And it's interesting, if I can just say, at the University of Virginia, one of my, another patent professor, John Duffy, and I, we just did a course, a short course that we built around a hearing. Judge Ellis from the Eastern District of Virginia came and held the hearing at the University of Virginia, and it was supposed to be a Markman claim construction hearing. And then he contacted us, and the students attended, and he's like, well, there's some motions to dismiss on subject matter, and I think I'm going to hear those as well. And this was a suit, TLI Communications, a non-practicing entity. I call it TLI Communications versus everybody, because they've sued Facebook and Twitter and Pinterest and Instagram and any social media company you could think of. I mean, Google. They're all there. All these lawyers, tromp into the the room. And, you know, the claim construction was interesting, but he handed down his decision like 2 weeks later, and it was subject matter eligibility. You know, this is not patent eligible subject matter. So going back to what I was saying about safety valves, a way of getting rid of problem patents or dealing with these problems in the system, perhaps, and I don't know that he was completely comfortable with the laws articulated by the Supreme Court, but and it's followed by the Federal Circuit, but the way it is, this is a way of getting rid of some of these problem patents. So
Thank you.
I'll say that.
Thank you. Well, I have to say, I think this has been a great panel. I did want to make a side note, which I think is kind of a neat note, is that Margo's mom is here.
My mom is
in the
here.
back, which I have to say. So I spoke with her, and she said, "I'm just the mom." And I was like, that was the biggest understatement ever. But I also wanted to say thank you to Rachel, who is a brilliant colleague and has done an amazing job with this. And I want to thank the Natural Resources panel for switching with us.
Thank
You
you.
guys are awesome. We really, really appreciate that. Thank you, Raquel. Lee,
Yes.
who has been awesome. We're also
Totally
very
awesome.
thankful for that, and we're thankful for Brandon Abel for helping us with this technology issue. But thank you all, and thank you to Professor Sprankling for your great work.
Yes, thank you.
I know
Thank
we
you,
took
Joseph.
a couple of mini breaks.